Namaskar and welcome to Insolvency Veterans, a unique talk show where you can hear the experts and practitioners who have been instrumental in shaping and implementing the Insolvency and Bankruptcy Code IBC and who have a deep understanding of its implications and challenges. I am your host, Rajesh Sharma, a former member of National Company Law Tribunal. In this talk show, we will explore various aspects of IBC, such as its objectives, principles, processes, outcomes, and impact on the Indian economy and society. We will also discuss the current issues and challenges faced by the stakeholders involved in the insolvency resolution process, such as creditors, debtors, resolution professionals, adjudicating authorities, regulators, and the courts. In each episode, we will be having an eminent guest who is either a sitting or former member of NCLT or National Company Law Appellate Tribunal NCLAT, senior functionary of the Regulator, Insolvency and Bankruptcy Board of India, or a renowned expert in the field of insolvency law and practice. Today, we are honored to have with us Shri Vijay Pratap Singh. Mr. VP Singh has a rich and diverse experience in the judicial field. He started his career as a Munsif magistrate in 1979 and rose to the rank of additional district and session judge in various districts of Uttar Pradesh, and he also remained principal district judge in 4 districts of Uttar Pradesh. He also held the prestigious post of judicial member of Trade Tax Tribunal, Meerut, and chairman of Permanent Lok Adalat, Ghaziabad. He was also elected as president of Uttar Pradesh Judicial Service Association, and he also served as Secretary General of All India Judges Association, representing the voice of subordinate judiciary in India. In 2016, he joined as member judicial of National Company Law Tribunal and served the benches at Allahabad, Kolkata, and Mumbai. During late 2019, he was elevated to the post of member technical of National Company Law Appellate Tribunal. I would also like to mention that I and Mr. VP Singh have a special bond of professional respect with each other. We both served together as member of National Company Law Tribunal, Mumbai bench, and worked on many cases which were upheld by Honorable NCLAT and Honorable Supreme Court of India. We are honored to have him on our show today. But before we begin our discussions, I would like to explain the meaning of the name of this talk show, Insolvency Veterans. The name is a thoughtful play on words that captures the essence of the IBC. The word in has been mentioned in red color, which signifies the state of financial stress or insolvency that many companies face due to various reasons. The word solvency in black signifies the aim of the IBC to restore the financial health and viability of such companies through a time-bound and transparent resolution process. The word veterans refers to the experts and practitioners who have been involved in the evaluation and implementation of the IBC and who have a wealth of knowledge and experience to share with us. Thus, the name of Insolvency Veterans reflects the theme and purpose of this talk show, which is to educate and enlighten the viewers about the IBC and its impact on the Indian economy and society. Please join me in welcoming our esteemed guest of the day, Mr. VP Singh. Welcome.
Thank you, brother Mr. Rajesh Sharma ji, and I am very much thankful that he has given me opportunity. Certainly, I am highly thankful to Mr. Sharma, who has also held bench with me in Mumbai bench of NCLT. I am associated with the work of NCLT from day one when NCLT was created. It was created on 1st June 2016, and from day one I am in this institution. And after the working in several national company tribunals, first of all I joined as NCLT member, judicial member NCLT in Kolkata bench. After that, I got opportunity to serve in Allahabad bench, and thereafter I was shifted to mm, in Mumbai bench. And most of the about pendency of the insolvency work, most about 40% pendency belongs of the insolvency cases belong to that area, only Mumbai bench area, and 60% rest of the country. We, I, along with Mr. Sharma, has got the opportunity to work in a place, in a jurisdiction where most of the insolvency cases were pending. Certainly, and I also got the opportunity from the work of NCLT Mumbai. I also got the opportunity after my elevation to National Company Law Appellate Tribunal.
Thank you, Mr. Singh, of joining the talk show. Mr. Singh, in your opening remarks, please share your thoughts about this talk show initiative, Insolvency Veterans, and how do you perceive that it will be helpful in furthering and strengthening of the IBC regime in India?
Mr. Sharma, first of all, IBC, from the day one when IBC was implemented, it was very difficult to work because there was no precedence. When a law is developed, then where their working is very easy because precedents are there and you have to follow the set precedent. Here, when IBC was implemented, it was a great challenge before us because every day law was being changed by higher courts and we have to follow that. Initially, when the first case was, I also got the opportunity to deal with the first case in India. Electro Steel India was admitted to insolvency, and that was the first case decided in insolvency matter. And certainly, that was a successful. After that, it was successful resolution was passed for the Electro Steel India.
Mr. Singh, a few words about this talk show and how is it going to impact the strengthening and of the IBC regime in India?
IBC, prior to this, so many different fields were there, but insolvency code was a unified code to deal with the matter because it is the main idea that survival of the fittest. If a company is sick and it is there is huge loan and so many employment, and companies are not running, then certainly a person, prior to this, there was no exit route. Insolvency code provided the exit route also. If a company, suppose there is an investment, a huge investment, and company fails for any reason, but there may be policy change or any, then certainly person who is capable of running the company should come. This is the policy behind this. And this has been very successful idea, and most of the companies, Bhushan Steel and so many successful companies have been taken over by the unsuccessful fellow, so many companies which failed has been taken over by the successful companies, and it is running well, and it saved the employment of many persons.
I must mention here that normally we have the pronounced judgments in front of us to read and elaborate its findings. The thing which makes our talk show, Insolvency Veterans, a unique one is that it is a rarest opportunity for our audience where judge himself is disclosing as to what was going on in his mind while writing a particular judgment. For that, judgments which have been delivered by Shri VP Singh, he is here today himself to elaborate on that. Mr. Singh, what is that inspired you to choose and shape your career?
Because I'm in this career, I joined this career in 1979, and it was my earnest desire to serve as a judge. I was thinking then certainly I got the opportunity and I served in different capacities. As I have been chief judicial magistrate, I have been assistant district judge, I district judge, principal district judge. There are so many places I got the opportunity. Judge tax tribunal. So after that, I got selected in NCLT. Certainly different type of work, though I was not in law. Commercial law was I was not aware with the commercial matters. Certainly, when I got the opportunity to serve in NCLT, I had to read so many.
You see, I'll share my own experience of sitting and working with Mr. VP Singh. We shared the bench. When I took over and started sitting on the bench, my first exposure was with Mr. VP Singh. And I must tell you that although he has been modest in saying that he was not having commercial law experience before NCLT, but I must say the nag he is having on the judicial front, that is tremendous. And Mr. Singh, I think it's your first love to be in judiciary.
Yes.
Yes. What are some of the biggest challenges or obstacles you have faced in your journey?
It's a challenge everywhere. Suppose I was dealing with the case of Jet Airways. That is the first case after hearing both the parties, opposite party was there, and it was admitted within 24 hours by the Bombay bench of the NCLT.
Jet Airways is again in news, but for wrong reasons again. What are some of the most valuable lessons you have learned from your experience?
Lesson, because in this field, lawyers or judges, they used to learn every day, and no one can say that he is perfect unless he is a Supreme Court judge. Because every day we are learning, even from a junior advocate who is appearing, who are appearing before us, we used to learn from them also. So we cannot say that yes, no one can say that he is all perfect. Every day in court, every judge, every day he used to learn.
So nice, so nice. How do you balance your personal and professional life, Mr. Singh?
It's a big question because when I have served, in this career, I have served about 42 years in different capacities as a judge, and after that, after my retirement, I am serving as an advocate. I am so much involved in this profession that I cannot. I am totally involved in this profession, and certainly when you are 24 hours you are involved in this profession, you do never get time for your family. It's a bit difficult task. It has been a challenge, but certainly is the sacrifice of the other spouse, so that you get the opportunity to serve in this department.
Mr. Singh,
If I am successful, I certainly I can say that it is a great cooperation from my Mrs. Singh. That's why I could get the time. Although I could not spare time for the family matters. Everything was dealt by her only, and I devoted every time for this profession only. And it was her cooperation that I could get success.
I am an eyewitness to what Mr. Singh has just said. He eats and sleeps with the judgments. Is it true or not?
It is 100% true, because what happened? Certainly, so many important persons were there, and workload was there. NCLT, when NCLT was formed, and when IBC came, every court was overburdened. We never get time for even for 1 hour for personal. Only when we get time, when we used to go to home only from in the evening after 6 from 6 from 7 p.m. to 10 p.m. After that, in the morning, I have to. I am early riser. From 4 a.m. to 11 p.m. every day I was involved with this profession, and I never got and that habit is still continuing. Even after retirement, if I suppose on a particular day I don't have so much work, even then my habit is there, and I used to read something even after live law and what happened what is the development of law, what is the cases decided by NCLAT, what is the cases decided by Supreme Court. Even though it is not concerned with me, but it is my habit, and I used to read that.
So the well-known saying that old habits die hard
Yeah.
is holding
It's
absolutely
100%
right.
true. It's 100% true.
Okay.
I am trying to forget that, but I failed to.
Although Mr. Singh, you have delivered ample number of judgments as member NCLT and member NCLAT, besides those civil and criminal cases which you had delivered during the course of your judgeship in UP judicial services, our research team has identified a few judgments worth quoting and discussing with you in person in this show. Let us take those cases one by one. In one of the case where both of us were sitting together, and I remember distinctly that that case was earlier heard by the previous bench, and since because of reconstitution of bench, the case was reheard by our bench, where brother and myself were sitting together. If you remember, brother, there was a case Deccan Value Investors versus Deutsche Bank.
Yes, I remember.
And okay, I'll also share something with you later. But please tell us something about that case because it was one of the case which was not strictly as per IBC. Both of us took a decision not strictly as per law, but it was required in that particular case, and that case has gone not only up to NCLAT, up to Honorable Supreme Court level, and Honorable Supreme Court finally decided this case same way the way our bench had passed the judgment. Brother, please.
Yes, we have decided this case, Deccan Value Investors case. Certainly, the matter involved in this was a virtual data room. What happened in this? Bid was submitted on the basis of record available in virtual data room, and resolution professional has not uploaded the correct some important report that was necessary to assess for the situation of the property that is to be for bid was going on. And when bid was submitted and committee of creditors accepted that bid, after that immediate application was made. Party made an application before the resolution professional that I want to inspect the particular property because I have an information that some other report was called from your side, and that report was not uploaded on the in virtual data room. So I want to inspect that property. It was also informed to the resolution applicant that the plant 12,500 metric ton fresh plant where is to be installed, there is no land for that, although it was provided that yes, land is available. So, and in that condition, application was made before us under section 60 subclass 5 of the insolvency code. I should be permitted to withdraw from this resolution plan, although application was submitted before the adjudicating authority for approval of the resolution plan by the resolution professional. Before passing of that order, because the committee of creditors has passed the resolution, has approved the resolution plan, and after that application was filed under section 60 subclass 5, we are, and yeah, it was argued before us, virtual data room correct data was not available. How can there was no opportunity to assess the property? There is no provision for withdrawing the from the resolution plan. Then, in the circumstances, we verified from the record, yes, certain important MMT report, McDonald report was there something, and that was not uploaded in the virtual data room. When we decided that yes, there was mistake from the part of resolution professional, then we decided that at least he should be permitted to bid again, although there was no provision, but in the interest of justice, we permitted that. But at the same time, when I passed, I prepared the judgment, but after that, I gave the judgment to my brother, Mr. Rajesh Sharma ji, and he, as member technical, with the idea, there was the data was not available in the virtual data room, so the resolution applicant has bona fide claim on this regard, but he should not be given benefit of this refund of earnest money deposit. In that application, resolution professional was saying that he should issued a letter for submission of a performance guarantee, but instead of submission of performance guarantee, he filed an application for withdrawing from the resolution plan, because before acceptance of the resolution plan. Then, in the circumstances, we provided, although there was no such provision, but in the interest of justice, we provided that within 30 days, we should, on the suggestion, within 30 days, he can submit to a resolution professional to invite fresh bid, and if he participate in that, but on the same bid bond guarantee, and if it is accepted, it's okay. And on the suggestion of brother Mr. Sharma, it was his clear advice. Yes, we should add one thing, that he will not get refund of that earnest money deposit. And I added, I always respected my brother's suggestion, and I added that. And this order was confirmed, although this bid was not accepted finally, because in the second bid also he could not complete the bid, and ultimately property goes to somewhere else, and he never got the refund of that amount.
In nutshell, what we did is that we allowed rebidding, which was not strictly as per law. We allowed the prospective resolution applicant to be a part of the rebidding process. However, we made a rider that this bid bond guarantee of rupees 40 crore will not be refunded to him. It can be considered for rebidding, and if he is successful in rebidding process, only then it can be adjusted against the fresh bid. Otherwise, the amount of bid bond guarantee will be forfeited. And we are really happy to understand that Honorable Supreme Court has confirmed our decision as it is.
One thing I would like to highlight in this thing, because certainly our experience, I have to share my experience. Then so many persons, like young one, I would like to highlight something about the judgment. This judgment was passed on 27th September 2019. Date is particularly important, and I would like to highlight few things which may be helpful to others. There was certain amendments. The judgment was passed on 27 September 2019, and we have taken, and 4 days back a Supreme Court judgment came, and we have cited that, and we have considered that judgment, and following that we have passed this order.
The point my brother is trying to highlight is that even 4 days past judgment was taken into account while passing this judgment.
Yeah, I would like to say that on 24th September 2019, Committee of Creditors of Amtech versus Dinkar T. Venkat Subramaniam judgment was passed, and we have taken few guidelines from there. And and after that an amendment which was passed by the IBBI. Based on that, we have considered the amendment, IBC Amendment Act 2019, number 26 of 2019, effective from 16th August 2019. And we gave, and by following these two, the Supreme Court judgment on 24th September, we passed the judgment on 29th September. We were being updated on daily basis, and everyone who is in this profession is expected to be aware with the current law at every time. We were following this. I can't say that.
Brother, in one of the case in NCLAT, you passed a judgment with respect to utilization of money which will be recovered from PUFE transactions. That is, if I remember correctly, it is 63 Moons Technology versus DHFL.
Of course.
Please elaborate something about that.
Yes, very important case was decided when I was in NCLT, because the 63 Moons Technologies case, this appeal was decided by the Principal Bench Delhi, and judgment was written by myself. And in this resolution plan was approved with 100%. Committee of Creditors had approved the resolution plan with 100% vote share, and issue was before us whether outcome of the avoidance transaction can go to the successful resolution applicant. Reserve Bank of India and most of the all the banks, financial sectors were of the view that this should go to the successful resolution applicant. And I found when the matter was being discussed, it was I found that yes, notional in the resolution plan only 1 rupees notional value was given for the avoidance outcome of the avoidance transaction, and that amount was not little amount. About 45,000 crores was involved in avoidance transaction, and it was passed by the committee of creditors. Yes, this outcome of the avoidance transaction shall go to the successful resolution applicant, and that money was in that particular case. I found that that money belongs to the provident fund, fixed deposit holders, and everything, and that if the chances were most chances were there that recovery will be possible.
As a matter of fact, fixed depositors, being unsecured creditors, were allowed rupee 1 in this.
No, only not only fixed depositors. This 45,000 crores belong to the PPF deposit and everything. Yes, some state electricity department invested pension money. In rupees 1, they were. What happened? It was the view of the question arises. This should go committee, the discretion of the committee of creditors, and committee of creditors with 100% vote share has passed this. Supreme Court ruling was clear that is adjudicating authority or NCLT or NCLAT can't change that, and it is abide by the decision of the committee of creditors.
Commercial wisdom of commercial
wisdom supreme. But question is whether commercial is this particular case was specific where adjudicating authority had not taken any decision. What happened in this? But adjudicating authority wrote in his order that we have taken opinion of the committee of creditors, and committee of creditors has passed that this outcome should go to the successful resolution applicant. Although there was a judgment of the Delhi High Court in Venus Recruiters case, wherein it was clearly held that yes, the outcome of the avoidance transaction should go to creditors of the company. It cannot go to the successful resolution applicant. But it was highly objected by the financial creditors. After that, and in this case, the DHFL group and the Reserve Bank and most of the top legal advocates represented this case. Dr. Abhishek, Manu Singh, everyone was there in this case, and they argued that this is beyond the powers of NCLT and NCLAT to look into the merit of that committee of creditors decision. But certainly, I followed the judgment. Constitutional Court judgment was there in Venus Recruiters, and I followed that. And in NCLT, it was decided that outcome cannot go to the successful resolution applicant. It can go only to the creditors of the company. And after that, this single judge judgment was again upheld in appeal by the division bench of the Delhi High Court. And after that, it is now at present it is sub judice before the Honorable Supreme Court, and we hope that the final outcome will be there.
As a matter of fact, brother, the way I look at it is the successful resolution applicant has no locus standi with respect to the PUFE transactions recovery, which will come to the corporate debtor.
Yes.
Reason being, he was nowhere when the PUFE transactions took place. Yes. Only the creditors sacrifice gain of PUFE transactions, and if at all it has to come back, it has to come back to creditors only.
Creditors only.
More so. if we give it to the successful resolution applicant, this money, there is a possibility that he has spent rupees 100 and he is getting back 500 rupees from PFE transactions.
Yes.
He is getting the company, he is getting the resolution plan through resolution plan, and he is getting the money also.
Money also.
There can be a possibility.
Yes.
So this thing, in principle, I do not agree. And I totally agree with you, what you said in that case.
Thank you.
There was another case.
I'm eagerly waiting the judgment of the Honorable Supreme Court in this regard.
Hopefully, Honorable Supreme Court should be. So since the matter is sub judice, we should not make arguments. But of course, as on today, the decision is this. Okay. As far as this, there is another case on the issue of limitation and balance sheet acknowledgement, a subject which is very close to my heart also. That is Bishal Jaswal case, 5-judge judgment of Honorable NCLAT. What was that case, and how did you afford to deviate from the set principles?
Yes, this is a very important case, and this judgment has a I will tell everything about this case, because there was a judgment of 5-member bench of NCLAT V Padam Kumar case, and headed by
the then chairperson.
The then chairperson. And certainly it was V Padam Kumar case. It was held that acknowledgement of debt entry in balance sheet cannot be considered as an acknowledgement of debt, and because it is compulsory. In balance sheet entries are made under compulsion. It can't be a free
for statutory compliances.
For statutory compliances, and based on that, bench decided. 5-member bench of NCLT decided that balance sheet entries cannot be considered as an acknowledgement of debt. But there was a case law of the Honorable Supreme Court in Mahavir cold storage case, and in that Supreme Court has clearly held that acknowledgement of debt, balance sheet entries shall be considered as an acknowledgement of debt. In NCLT, I had one side there was a judgment of Honorable Supreme Court in Mahavir cold storage and so many other cases, and after Bengal silk mills and other cases also. On other side, 5-member bench of NCLT, as per norms, don't have power to give a different verdict than the 5-member bench judgment. Then I thought that this bench decided in NCLT, it was decided by the bench that we should refer the matter to the chairperson, and reference be made to consider the judgment of the Honorable Supreme Court and rethink over that matter. So when the matter went to by then the main chairperson retired and acting chairperson took place and took the charge. And after that, when matter goes before another bench, 5-member bench was considered. This bench decided immediately. This 5-member bench decided again that earlier judgment in V Padam Kumar holds good, and this 3-member bench had no right to question the genuineness of the question that judgment, and even stricture was passed by the another bench. When stricture was passed, then we file and writ petition, personal writ petition before the Honorable Supreme Court against the stricture, and on the day of admission, Justice Norman immediately set aside that judgment of the strictures passed against us, and the judgment view taken by us by following the Supreme Court judgment was finally upheld. And Bishal Jaswal case is very important, and today it is the law that acknowledgement of debt is accepted, and balance sheet entries are treated as an acknowledgement of debt for consideration of limitation.
As a matter of fact, brother, I must admit that you had to face some unpleasant circumstances during that period.
Judges, and if you are giving a dissenting judgment, you have to face the challenge on several occasions.
Brother, as a matter of fact, being a chartered accountant and being on the other side of the bench also, I can say with almost 100% degree of certainty that the balance sheet is most sacrosanct document during the continuance of business of a corporate debtor. How I say so? Because that is the conclusive proof that what is to be paid, what is to be, until unless there is no fudging in balance sheet.
You are perfectly right, and you are telling whatever you are telling is based on your experience. I don't have any personal experience about accountancy because you are more expert in this field. But I can say that my experience was my order was only based on the Supreme Court judgment in Mahavir Court.
It is the conclusive document, if at all any document is to be relied upon.
Yes.
Uh, Another case where you played your role was Spade Financial Services, Hari Kishan Sharma. What was that case, brother?
Yes.
It was relating to related party transactions,
Yes,
if I
yes,
am
it
not
was,
wrong. Yes,
it
yes, yes,
is,
yes, yes, yes.
about related property transaction.
Yes.
What happened in this? Um, the in IBC it was a provision that yes, related party cannot participate in COC. Income cannot be member of related party, cannot be member of COC. What happened in this? The person, the earlier director, who was director and who was the company was under his control. He before the formation initiation of CIRP, immediately he resigned, and it was pleaded from their side. Yes, on the day when the CIRP was initiated, I was not director, so I can't be treated as a related party. Though there were, as per rules, certainly only related. What is the definition of related party in IBC? Certainly he was not covered. But when I was dealing with this case in NCLAT, our bench decided yes, because he had full control. He has been in under the company was under his control for about 10 to 15 years. Even every policy was decided by him, and simply to getting out of clutch of this, and he immediately resigned, and the CIRP was initiated, and again he wanted to take the charge of COC. He was having maximum shares in the financial in the company. So even after initiation of CRP, he wanted to use his position in the COC. My bench in NCLT discouraged this, and we passed an order. No, he can't be treated as he can't participate in COC, and he is an interested. He will be treated as a related party. And when it meant to the Honorable Supreme Court, certainly in Phoenix International, this present CGI, the Honorable Justice D.Y. Chanchur wrote that judgment in Phoenix International, and he upheld that part of the judgment, which says that yes, not in presentile, will not related party will not be considered only for in presentile, but in past also, if he has been in control of the affairs of the company, he will be treated as a related party.
In fact, you gave precedence to substance rather form.
Yes.
In substance, he was holding the charge of the company.
Yes.
However, in the form, he was saying, I am not a director.
Yes.
In one case, brother, you have very clearly distinguished between Form 3 and Form 4 of Section 8 notice, that was Neeraj Jain cloud water streaming technology case.
Yes, very important case.
Yes.
Flipkart.
Flipkart case.
I got the opportunity to deal with this case in Delhi, Principal Bench Delhi. That is very important case. What happened in IBC and for operational creditors, if there is an operational debt, then notice is to be given under Section 8. And as per rules, it was the discretion. People before this judgment, everyone was thinking that it is the discretion of the operational creditor either to give notice in Form 3 or Form 4. But in this case, I differentiated. No, it is not the discretion. Where in it, I held that yes, this our bench decided where the transaction, the receipts are issued and invoices are issued. In that case, I invoices. Then in that case, form notice in Form 3 can be Form 4 can be given, and where invoices are not issued, then in Form 3 notice can be given.
Brother, I remember when we were sitting in Mumbai bench, I think it was one of the first case under Section 140, subsection 5 of the Companies Act.
Yes.
where we pass certain orders against the auditors, and those auditors went to High Court, got our orders set aside. Finally, Honorable Supreme Court, just 2 3 months back, I was reading somewhere, Honorable Supreme Court upheld our decision.
Yes, this is very important case. What happened after the amendment of companies, the 2013, when the Companies Act 2013 was implemented, Section 140 sub class 5 came into force. The Ministry of Corporate Affairs initiated some action against the top Indian auditors, just like Deloitte, top five, Deloitte, BSR, and
Deloitte and BSR.
BSR. And but in that case, just when action was initiated by the Department and Ministry of Corporate Affairs, they filed an application that this court, NCLT, had no jurisdiction. And because Deloitte filed an application that he has already resigned from the, and this NCLT has jurisdiction only when audited to remove. NCLT can initiate action under Section 140 sub class 5 to remove a director for 5 years. But when a director has already resigned, auditor has already resigned, auditor has already resigned, then no action can be initiated. He cannot go out of clutches. And we decided that no, section 1, applicant has raising false applicant's objection has no force, and we decided that yes, proceeding under section 140 chapter 5 of the Companies Act 2013 can go on. But in that case, immediately, Honorable Bombay High Court heard the argument and
Set aside our
after that, it set aside that order of the NCLT and stayed that proceeding in NCLT. But when the High Court order was challenged by MCA, Department of Ministry of Corporate Affairs, before the Honorable Supreme Court recently, Honorable Justice Shah gave that judgment. The Supreme Court decided that the view taken by the NCLT was correct, and the NCLT can take action even after resigning the director or auditor. It cannot go out of the clutches of out of clutches, and proceeding can be initiated against him under the Companies Act under Section 140 sub class 5.
Thank you, brother, for your giving insight about the cases which have been pronounced by you, and majority of them, rather almost all of them, have been upheld by Honorable Supreme Court. Now let us go one step forward now, brother. You see, when we talk about overall IBC regime in India, and you have been involved with this IBC regime from day one, when the NCLT was formed and you took over charge. What is your assessment with respect to the road of IBC we have traveled till now? Where are we standing? And what are the course corrections required for further strengthening of IBC regime in India? We can break it in three parts: where we are, what we did, where we are, and where do we go.
First of all, I can say that this IBC is the only, it is most successful. Implementation of IBC has been most successful till date. But there are drawbacks in this. In this, greatest drawback, suppose in operational characters, there is injustice with the operational character. If a operational character has initiated the process, entire CO the claim is filed by the financial sector and they took control of that. Operational sector never sit in the COC and they used to share the property. Everything is proper in the IBC. CIRT is initiated by operational character and he gets nothing. Every benefit comes to the goes to the
But one
financial
one
sector.
brighter side of it is, brother, that operational characters, the moment he files Section 9 application, and if the company is having capacity to pay, if they don't have the capacity to pay, they are going to be into insolvency. But if they have the capacity to pay, almost 70-80% of the operational creditors cases are settled before
Yes.
before initiation of CRP.
Yes, yes, yes.
And that way it has become a good big tool for operational creditors to recover their money.
90% cases
90%
are
of the
settled
cases.
at the initial,
You
before
know,
initiation of
I,
CIRP.
I was modest in saying 60-70%. You have been rightly saying 90% of the cases.
They decided
So,
before initiation of
so
CIRP.
that way it is a big tool which has come in the hands of operational creditors
Yes.
to recover their money on a faster basis.
One thing I would like to say, मतलब कि my journey from NCLT to NCLAT, the one message I can say, lead today. In NCLT, whether it was in Calcutta, in Delhi, or in Mumbai, or NCLT, some young lads and young professionals are very successful. But why only 5 to 6 senior advocates are getting chance to argue the case? People should, matlab कि litigants should have faith in their young generation. And if they are given chance, I found that in so many nowadays, what is the law is available at the iPad. Everything is available on iPad, and young professionals are more familiar with this, working on this. They can search out, and they are very much familiar with this. But even though a litigant has always believed that only 5 seniors or 10 seniors in a place, if they are getting chance, then only he can win. And even though at the cost of his using the business, one it's a drawback in the system. In either in NCLT or in NCLT, everywhere only 5 to 10 advocates are captured. Senior advocates have captured the field, and young generation are only taking.
You mean to say that the concentration with a few advocates or few counsels should be dispersed
Yes,
in
young junior. Yes, second line should get the chance, and they should. मतलब कि people have faith,
You
and
know,
they are well prepared.
I
Found the
remember
case.
I remember one day a lady, young advocate, came to us and she was seeking an adjournment because her senior was not there. Both of us were sitting in the bench and we encouraged the lady, young girl, 25-30 years of age, very young girl. And she said, Milord, give us an adjournment because my senior is not there. We said, no, no, you argue. She argued her case so perfectly, and that day only we admitted the case into insolvency. She must have gone inspired, and I think next time onward, she must have encouraged to do the work
Yes, yes.
in a better way. You see, I'll cite one example when we were sitting together. Normally, it is considered that the judges are very serious. They mean serious business only. Sometimes, but we are also human beings. I remember when both of us were sitting in Mumbai, one party in person came to us for arguing its own case. Brother and myself were asking few questions from her, and every time, she used to take about 2-3 minutes in going to that particular paper and answering our questions. It happened about 3-4 times. Then I whispered something in my brother's ears, and we had to adjourn the case. And it was in later when I said कि ये धीमी गति के समाचार हैं, इनको समय दे दो आगे के लिए. You remember, brother? So judges are not always serious. They also have wit, they also have humor, but they do not disclose it to the public. That is right, brother, or not?
Yes, yes. Case, when a case comes, we all are. It is supposed that judge has to read the file. He is well prepared with the case, and we only think that a person arguing the case, a professional, when he is arguing the case, he should present the case. It is the judge who is already read the file. He is well acquainted with the facts and law. He will decide the case. But even for the adjournment, they used to engage senior advocates. That is very sad part for only adjournment. If you are unnecessary adjournment should be avoided. And if a case is filed, it should be decided in one way or other. But if it is pending for years to year, and every day the tarikh per tarikh should be avoided, and then certainly it costs the litigants very much.
With this, we come to the end of this session. Thank you very much, brother, for coming and honoring us.
Thank you very much for providing me an opportunity